I'd like to introduce now the speaker for the grand finale. David Kee is a native of Cayuga, Ontario, and graduate in commerce from Queen's University and a graduate of the University of Toronto Law School. He was called to the bar in 1968 and practices law with a firm called Blake, Castles and Graydon, who I understand occasionally do a bit of bank work. David probably can't, because of his client, can't tell you much about the inside story on Mary the Happy Teller, but he can fill you in on everything you've always really wanted to know about red convertible loans. David?
Thank you, Jack. I noticed, you can say one thing about Cayuga. I don't know what connection it has with banking, but I see from the paper this morning that it's a good place to buy land. That's the area that's right near Jarvis, which seemed to get in the Globe this morning. My topic is banking and commercial law, and in this regard you have a paper which you received yesterday and which is relatively short, and I hope you'll look at it because I'm not going to cover many of the points covered in that paper. This topic is a broad one, and today I hope to refer to matters which need not be confined to banking situations. You will note also that the paper deals with general banking practices, and of course it may be that practice of any particular bank in any given circumstance will vary. At the outset, and this isn't covered in the paper, I would like to say a few words about the relationship between the bank and its customer. As all of you know, the relationship is based on contract. Sorry? There it is. Is that better? Can you hear me now? The contract consists of certain implied terms which are recognized at common law and express terms which are, of course, contained in the forms executed by the customer. One of the implied terms is that the bank has a duty of confidence to its customer and accordingly will not or should not disclose information concerning the affairs of its customer to other parties unless the consent of the customer to such disclosure has been obtained or unless the bank is under an obligation to disclose the information at law. This is not an exhaustive listing of the situations in which the bank can disclose information concerning its customers, and for general discussion I would refer you to the Tournier case, which I have not cited in the paper, and that's at 1924 1 King's Bench 461. This duty of non-disclosure is of practical importance if you wish to subpoena a bank manager to produce bank records in a civil action in which you are representing one of the parties. It is general banking practice not to disclose the documents to the solicitor who has subpoenaed them, but to require the attendance of a bank official at court to obtain a court order requiring the bank to disclose the documents. In other words, the banks take the position that the subpoena is not a sufficient compulsion to overcome the bank's duty of non-disclosure. In this regard, the case of Houghton and Houghton, which is not cited in the paper, at 1965 1 OR 481 is of relevance. The practical consequence is, of course, that you will not have a chance to examine the documents until they are produced in court during the trial. The bank need not produce originals of the bank records, but under Sections 34 of the Ontario Evidence Act and Section 29 of the Canada Evidence Act can produce photocopies of those documents. These sections, in addition, generally speaking, provide that a bank official is not compellable to produce any record which can be produced by affidavit or to give evidence concerning any matter which can be proved by the documents, unless a special court order is obtained. It might be argued that these sections, by implication, overcome the duty of requiring a bank official to attend and obtain a court order before the records are produced. However, the sections don't specifically go this far. I understand it is still general banking practice to not produce records until a court order is obtained. On the other hand, in advising your client, you should keep in mind that records provided to the bank can be producible if the proper steps are taken. This could have an embarrassing effect. I recall an instance that came up this week where a man had provided the bank with a detailed explanation of his net worth. In fact, he gave the bank a lot more financial information about his worth than he told his wife. And of course, there's a subsequent alimony action, and there's a rather unhappy man now in Ontario, because the bank, of course, will have to produce that information. The relationship between the bank and its depositor is one of debtor and creditor, which is the bank, of course, is a debtor of the customer to the amount of the deposit. Accordingly, bank deposits are subject to those remedies available to a creditor of the depositor, such as garnishment and seizure by way of execution. For authority for the latter proposition, there's the Attorney General of Ontario and the Royal Bank, which is a 1970 2OR 467. Seizure and attachment will cover only those assets on hand at time of service and will not attach deposits made after the notice of seizure or after the garnishment order is served. In addition, if the customer is indebted to the bank and such indebtedness is either in default or payable on demand, then the bank will have the right to set off the balance in the deposit account against such indebtedness. In the event that you're acting for a person who wishes to freeze a bank account because of a dispute concerning the control of the account or the ownership of the funds, then you should look at Section 95B of the Bank Act. This section should be strictly complied with and, generally speaking, requires the bank to freeze the account if there is served on the bank either a writ or other process originating an action in which the bank is a party and in which the money in the account is claimed, or in any other action in which the bank is not a party, a court order enjoining the bank from dealing with the account is served on the bank. You should note that the latter provision refers to an order made by the court, and accordingly this section would not be strictly complied with if the bank were served with a writ or notice of motion seeking an injunction or declaration with respect to the account, but not naming the bank as a party to the action. In passing, I point out that a writ or seizure served on a branch of the bank affects only property at that branch. In this regard, see Section 96(4) of the Bank Act, and under Section 2 of the Bank Act, the head office is defined as a branch. So by serving the head office, you don't automatically catch assets at other branches. I would briefly like to deal with the bank standard forms for the operation of an account. Probably all of you have at one time or another had your client execute these standard forms. And probably a great many have accepted these forms without question on the basis that the bank will not change them anyway. I don't think this is necessarily the case, and I recommend that you carefully consider the forms and propose such amendments as you think are reasonably necessary to protect your client. However, in the area of delegation of authority, I recommend from the customer's standpoint that the form of the bank's applicable authorizing resolution be passed in an unamended form if possible. This will lessen or prevent future requests by the bank for further resolutions to cover unforeseen banking transactions. One aspect of the bank's forms which I would like to deal with, and which is mentioned in the paper, is the verification provision. This provision, generally speaking, requires the customer to object to the statements, checks, or other vouchers received by him within 30 days of receipt, or he will be prohibited from making any subsequent objection to them. One of the purposes of this form is to put the onus on the customer to maintain a close watch over his accounting operations. This provision is of particular importance with respect to checks on which the customer's signature as drawer is forged, and prohibits the customer from making a claim after the 30-day period. An example of a verification provision and the effect of this clause is found in the Arrow case, which is referred to in the paper. I can recall that one of the first files I dealt with concerned this problem, and I think it's a typical one that could arise. We have a small businessman who's a mechanic by trade, and he's interested in his mechanics and installing things, and he really doesn't care about the accounting procedure at all. He's not really a businessman by nature. But his business was successful, he was making money, he was quite happy. His accounting was done by a 16-year-old girl who, as she grew older, grew wiser in the ways of the world and slowly started signing his name to the checks. This went never in small amounts, but it went on for a period of years and ran up quite a bill at the end. And he didn't know about it because he never looked at his bank statements until one day he wrote a check to buy a large purchase, and the check bounced. And needless to say, he was quite astounded and unhappy. And I won't tell you how the case turned out, but I will tell you that the clause was very effective. Needless to say, this is a requirement which will seldom, if ever, be waived by a bank. However, I would have thought that the verification provision would not be used by banks in situations where the error was caused by the bank's own staff or computer. In the paper, I refer to various bank requirements as to bank forms and evidence of registrations with respect to the form in which the customer carries on business. In this regard, I would like to mention in passing the amendments to the Partnerships Registration Act, which come into force on July 1 of this year. These amendments, among other things, provide for the expiration of registrations after 5 years. Any existing registrations will expire on January 1, 1975, and your client should be advised of this. Again, in passing, I point out the necessity of keeping in mind the distinction between the name of the entity and its trade name. This is shown in the recent case of Bradstreet, which is referred to in the paper, and in which an assignment of book debts was held invalid, although signed by the sole proprietor on the basis that the accompanying finance statement contained only the trade name of the debtor. Another area in which the name causes some confusion is when there is an amalgamation of two or more companies, and the name of one of the amalgamating companies is used as the name of the amalgamated company. Although under Section 196 of the Business Corporations Act, both amalgamating companies continue as the amalgamated company, it is general banking practice to require, in such a situation, new signing authority and new security documents. For instance, if I had guaranteed the loan of Company A, and Company A and Company B amalgamated and carried on business, continued to carry on business Company A, I would still be required to give a new guarantee, although the guarantee on its face would be identical to the previous one. The continuation provisions of Section 196 should be regarded cautiously in all situations. For instance, in the recent case of Whitco Chemical Company Canada Limited and the town of Oakville, which was recently approved by the Court of Appeal in the March 23 edition of the Ontario Reports on those blue pages. And the principle is that for the purposes of maintaining an action, an amalgamating corporation ceases to exist as a legal entity on amalgamation. At page 8 of the paper, deal with obtaining bank credit. Here it should be emphasized that the majority of bank loans or lines of credit will be on a demand basis, which means they can legally be demanded by the bank at any time. The customer should be aware of this fact and also should be aware of any margin requirements which the bank may impose with respect to draws on the credit. For instance, the bank may extend a $50,000 line of credit to the company on a demand basis, but may impose a requirement that no advances can be obtained under the line of credit if the total indebtedness resulting from such advances would exceed a stipulated percentage of the total receivables or the total receivables and the inventory. Demand credits may be either revolving or non-revolving. Under a revolving credit, as its name implies, the bank can reborrow amounts which he has previously repaid, provided the total amount of the credit is not exceeded at any time. The bank's interest rate with respect to demand and term credits is usually expressed as a fluctuating rate to be determined in accordance with the bank's minimum commercial lending rate or prime rate, terminologies differ, plus a specified percentage. The rate is usually higher for a term credit than for an operating credit, as you would expect. A term credit is not by definition payable on demand. However, it is general bank practice to have advances under the term credit represented by demand promissory notes. In this situation, the customer should obtain an agreement from the bank setting out those situations in which payment can be demanded on the notes, and perhaps an appropriate legend should be attached to the notes stating that they are subject to the provisions of this agreement. In many cases, the bank itself may request such an agreement in order to set out those events which would permit the bank to demand and accelerate payment. Typical provisions of a loan agreement are outlined on page 10 of the paper, and you will see that one of the provisions relates to specific covenants by the customer with respect to its operations, and these, of course, should be negotiated with the bank, as the general provisions may unduly restrict the intended operations of the company. In passing, I note that just because there are installment repayment provisions need not make the loan a term loan. And I've seen the practice of the banks to create a demand loan and say, well, this is sort of the implied repayment arrangement, but the loan is still is at the pleasure of the bank, and accordingly could still be demanded on demand at any time. Some of the types of security taken by banks are outlined in the beginning of page 12 of the paper, and I would like to deal here with a debenture security taken by banks. This form of security is becoming more and more common in the case of corporate customers, and it is likely that one or more of your clients will be asked to provide the bank with debenture security. The bank's forms of debentures are on a demand basis and consist of an unconditional promise to pay a stated principal amount at a specified rate of interest, and the promise is secured either by a floating charge or a combination of a fixed and floating charge. The banks have added to the haziness surrounding the distinction in terminology between a bond and debenture, as referred to in Paul Moore's paper, by normally referring to a debenture, calling it a debenture, even though it's secured by a fixed charge. Paul's paper also outlines the nature of the floating charge, and I think you should review this aspect when advising as to this form of security. The principal amount of the debenture may be in excess of the line of credit extended by the bank, and the interest rate will be a fixed rate which is higher than the current rate charged by the bank on a fluctuating basis. The reason for the increase in the principal amount is that it may be that the line of credit will be increased in the future, and by having a larger principal amount at the outset, the necessity of obtaining a new debenture in an increased amount may be eliminated. The increased amount in a debenture, of course, is not to be construed as a commitment by the bank to increase the credit to the amount stated in the debenture. Needless to say, the question occurs as to what is the legal effect of creating an unconditional obligation of the company, which may be, at the outset at least, in excess of the indebtedness of the corporation to the bank. The answer is that the debenture is issued to the bank on a conditional basis, and the terms of these conditions are found in the provisions of the pledge agreement. Thus, the bank's rights against the corporation under the debenture are governed by the terms of the pledge, and the debenture can be enforced by the bank only to the extent of the indebtedness of the customer to the bank. It is usual for the pledge provisions to state that so long as interest is paid by the customer with respect to its indebtedness, then no interest accrues under the debenture. The reason for the higher rate of interest is that the reason that the higher rate of interest is included in the debenture is so that in the event of realization, the rate of interest will not be lower than the bank's fluctuating interest rate at that time. As pointed out at page 18 of the paper, it is theoretically possible for the bank to sell the debenture to a third party who has no notice of the pledge, so that the party has the right to enforce the debenture against the customer for the full principal amount. However, to my knowledge, this has never been done by a bank, and it would be extremely rare for such an event to ever occur. In this regard, it may be that the customer can negotiate with the bank to have the negotiable feature removed from the debenture and the fixed interest rate expressed as a fluctuating interest rate in accordance with the terms of the indebtedness secured thereby. You might ask why this complicated arrangement is used. The reason is that bank loans may revolve, and if the pledge concept is employed, no argument should arise at a later date to the effect that payments made from time to time by the customer to the bank and subsequently reborrowed have been used to pay off the obligation under the debenture, so that at the time of realization, only a reduced or perhaps no amount is owing under the debenture. In addition, under Section 3.2 of the Corporation Securities Registration Act, the debenture, in order to be registered under the Act, must be accompanied by an affidavit of an officer of the corporation setting out the total amount secured by the debenture. If the debenture is an unconditional obligation, then the deponent can swear that the amount secured is the principal amount of the debenture. If the debenture were not pledged, it would not be possible to state in the affidavit the actual amount secured except on a collateral basis, and it is not certain under the Act if the amount secured can be so stated in the affidavit. Having said all that, the documents to be given to the bank will consist of basically a debenture, a pledge agreement, and a supporting resolution. In addition, the bank will require a solicitor's opinion from the corporation stating that the corporation is a validly existing corporation, has the power to issue and pledge the debenture, and that the debenture has been duly authorized, executed, and delivered, and constitutes a binding obligation of the corporation enforceable in accordance with its terms. The comments of Paul Moore yesterday with respect to legal opinions are applicable here. If the debenture does not purport to create a fixed charge on buildings and equipment, then it is unlikely that the bank will require an opinion as to the corporation's lands. Even if chattels and equipment are expressed to be subject to a fixed charge, and the bank would like an opinion with respect to those assets, I think that the solicitor's opinion as to title should, because of at the present time there is no central registry system for personal property, merely state that certain searches had been made with respect to the property and no registrations found. If the debenture contains only a floating charge, it may be that the bank will not require an opinion as to the company's title to its assets. I might mention that insofar as the floating charge and the fixed charge with respect to equipment are concerned, the debenture in Ontario need be registered only under the Ontario Corporation Securities Registration Act. Under Section 3 of that Act, the debenture must be registered within 30 days from the date of execution, and if the charge is one which is not secured by separate instrument, which is the case with a simple bank debenture, the registration consists of an affidavit containing the particulars set out in Section 3.2 of the Act, and attached to which is a true copy of the debenture. The debenture must be a true copy, and it is the practice of the Ministry of Consumer and Commercial Relations to not accept for registration a debenture attached to the affidavit if the debenture contains original signatures and the corporate seal. Accordingly, the debenture should be made into a true copy by putting quotation marks around the signatures and the words corporate seal over the impression corporate seal. An alternative would, of course, be to just photostat the debenture. Different registration requirements apply if the charge is contained in a trust deed or other instrument under which bonds are issued. And in this regard, you should look at Section 3 of the Act for the particulars of requirements of that type of registration. As mentioned above, the debentures are becoming more and more widely used, the reason being that the floating charge concept permits the bank to obtain in a simple document a charge over all the assets of the company, including such assets as industrial property, which would otherwise be difficult to charge. In addition, because all the assets are charged, the bank has the right upon realization to appoint a receiver or a receiver and manager with respect to all the assets of the corporation, and the receiver will have the power to wind up the affairs of the corporation in an orderly fashion, or if necessary, carry on the business of the corporation. I do not think that the task of providing the bank with debenture security need be a time-consuming or costly process. In the event that you are faced with a problem with respect to the nature of such security, I would recommend that you speak to the branch manager and have him arrange for you to contact the bank's general solicitors in an attempt to settle any confusion. And I'm sure that the bank solicitors would be willing to help. Dealing with security, I would also like to briefly mention that if the customer is providing security to other lenders, then consideration should be given to including in such security a provision whereby the bank is permitted to make advances to the customer and to secure those advances by security which will be prior to the charges contained in the other security. This was mentioned by Paul Moore yesterday, and I would like to emphasize that such provision should specifically permit subsequent advances by the bank to have priority in order to overcome the principle that advances made after notice of a subsequent encumbrance rank after the subsequent encumbrance. In this regard, I refer you to Dealey and Lloyd's Bank. That case is not cited in the paper. It's at 1912, Appeal Cases 756. Future difficulties, of course, could be eliminated if the proposed security were reviewed with the bank prior to execution. I would also like briefly to refer to the bank's guarantee forms, which are referred to on page 20 of the paper. You will note that the guarantee forms contain several provisions which permit the bank to deal with the customer and securities held by the bank for the indebtedness of the customer without releasing the guarantor from his obligation, which might otherwise occur under common law. In this regard, under the terms of the bank's guarantee form, it is possible for the guarantor to be liable to the bank even though the security held by the bank turned out to be invalid for any reason. This should be emphasized when advising a client who is about to provide a guarantee, because it may be that the guarantee is being given only because the guarantor feels that there are sufficient securities held by the bank to secure any obligation he would have under his guarantee. Such guarantor would, needless to say, be very disappointed if he found out that the security held by the bank was invalid and available to the unsecured creditors, and he was still required to honor his obligation to the bank. At page 27 of the paper, reference is made to certain services available to the customer, and mention is made of letters of credit as a method of conducting international purchases or sales. I'm not going into that at this time, but I would like to recommend a text which might be helpful if you're faced with a problem in this situation. I haven't mentioned this in the paper. It's the law relating to commercial letters of credit by a chap named A. Davis, and it's a 1948 English text. On the subject of text generally, dealing with banking and general principles of commercial law, there's, of course, Falconbridge Banking and Bills of Exchange, and there's a very valuable book called Paget's Law of Banking, which is an English text. It's a very helpful book. A service which is not included in the paper and to which I would like to refer is the lockbox service of the bank. Under this service, the bank processes the receivables of the customer. The customer's invoices will direct its customer to make payment to a specified box, which will be under the control of the bank. Of course, the bank's control wouldn't be specified in the invoice. The bank will open the mail, process the checks, and credit them to the customer's account, and in addition provide the customer with such accounting records he might wish with respect to his receivables. This service would be helpful if the accounting staff of the customer at his present level were overworked and couldn't handle any additional duties, or if he wanted some control problems. This completes all I wish to say this morning. You will note that I have not touched upon the fact situation, and I've left this to be dealt with in the seminars which follow. Thank you for your attention.